well, I want to see you succeed. But I need to have this money paid back. All right. It needs to be paid back. Because the state didn't create the kid. The state didn't, engage in any of those things you did. If you don't pay it back, you know me, Mr. Anderson.
He owed just $50 a month to pay back the taxpayers for the cost of his child's birth. His grand total paid after 18 months? A measly $5 bill. Benjamin Anderson is already sitting in a county jail cell on a separate child support case. But today, he's facing a judge for a completely different kind of accountability. He thinks because he helps raise his child, he can just ignore a court order. He interrupts. He complains. He even calls accountability a debtor's prison. But he picked the wrong courtroom to play the victim. Watch closely for the moment his entitlement completely backfires, and the judge hands down a reality check with the threat of 20 days behind bars.
We will go on the record in the matter 15 PA 33PJ in re the paternity of Rosaline. In re the paternity of ROA. Appearances are, we do have appearing in person, Benjamin Anderson in custody. On a different matter, we have his attorney, Emma Hanu, in person. The Corporation Counsel, Stephanie Thomas Schmidt, is here as well. We're set today for a sanctions hearing. Mr. Anderson was found in contempt, and a remedial contempt order with purge requirements was entered in this matter. The Child Support Agency alleges that Mr. Anderson has not met his purge requirements. Ms. Thomas Schmidt, you have the floor.
Your Honor, Mr. Anderson was found in contempt with a purge lasting 18 months beginning January 1st of 2025. We have received one payment on this file of $5 that was dated May 14th of 2025. There have been no other payments on this purge. Mr. Anderson has a separate child support matter with this county that has proceeded through the court process, through the contempt process, through the sanctions process during a comparable time period, separate judge, so separate order, so separate dates and such. And there has been some effort, though not complete effort, on that file, but yet while there has been attention paid to that file, Mr. Anderson has paid a grand total of $5 over the 18-month purge period, with his purge being $50 per month.
At this stage, the courtroom is no longer debating the amount owed. It's examining whether a court order was taken seriously. The financial total may seem modest, but the judge's attention is shifting toward accountability. The next few minutes reveal how both sides try to frame the same facts in completely different ways.
How much, what are the back or the rear just?
Approximately $1,309.32. This is a birthing expenses only case at the moment. And while it's not current support, Mr. Anderson is responsible for the creation of his child. He's responsible for the bringing of the child into the world. And it is appropriate that he provide support and contribute to his half of the existence of the child. That's the point of the birthing expenses, so that the total impact doesn't fall on the mother or the state on behalf of the mother. And $5 over the course of 18 months shows absolutely no consideration for this file, in light of the fact that the arrearages, the birthing expenses are only $1,300, and that it is simply birthing expenses and not continuing support for this child. I am requesting a sanction to be imposed but stayed, specifically 15 days, and that the purge be extended for a period of 1 year, remaining at making the payment of $50 per month. I think that's more than appropriate, given that there's been absolutely no attention or consideration to this file.
All right, Ms. Hanu.
Your Honor, as you know, Mr. Anderson is currently incarcerated until at least August 2nd on another support matter. Overall, I have no objection to the staying of the 15 days. I would also, in the alternative, I would have no objection to the court ordering it imposed concurrent with his current sanction. Mr. Anderson is involved in the child in question's life. He is the sole caretaker. It may not be relevant at this time, but I think it's important to know that the child in question, Rosaline, has severe autism. Mr. Anderson is the primary caretaker. There are not daycare facilities that are currently able to handle her high needs, which is part of the reason that Mr. Anderson has struggled continually and has continued to struggle to pay the birthing costs in this matter as well as the other matters. Continuing to have him sit in jail does not serve the state and does not serve the child. Mr. Anderson, in the other matter, he's employed, self-employed, he's a contractor. He does have an income, he does have jobs. He was waiting to be paid in full for a job when he entered into custody. So at this point, I would defer to the court.
Your Honor, if I may respond to that.
First, I want to know who is taking care of the child now?
Mom.
Mom, so you're the primary caretaker, but how much does mom watch the child or have the child?
Right now, well, obviously, because I'm in jail, she has her, but otherwise Rosaline's with me every night.
Every night? Then who watches the child when you're doing your work projects, because you do construction and those?
I take her with me.
Okay,
If she's not in school, she goes with me, or sometimes I get lucky if Ashley doesn't have to work, she takes Rosaline.
How old is she?
She's gonna be 11 on the 28th. And that I would have liked to have her in court because child support seems to not understand how much of an upkeep it is to have with the one. This is hard on her. It's not good. You're not just punishing me.
No.
You're not
Oh.
speaking to me.
Yeah, you can't do that. So
Yes, ma'am.
you can speak to me so I can understand things. And
It's,
I understand what you're saying. You're saying you're not punishing me, you're punishing, I can only call her ROA. You're only punishing ROA because I'm the one who takes care of her. I'm the one who understands how to take care of her. I get your argument. I get your statement.
I do her meds. I do her doctor's appointments. I do her school appointments. I do her IEPs.
And I can understand.
I
that
have
too.
recommendations from the school who said, as far as they're concerned, for a father, I've done amazing. And I'm doing this with,
Your Honor,
And
I'm
we're
going
not
to argue
saying
that
you're
this
not.
isn't relevant to the financial issue.
Yeah, and that's where I'm going here. I can see that and I can hear that. I don't know ROA. I haven't seen ROA. I haven't met ROA. I think Ashley's been here with you at some time in some point or some way. However, in this case, I do know, and I think you have said that you are the primary care.
This is where the hearing takes an important turn. The judge acknowledges the defendant's role as a parent, but makes it clear that personal circumstances and legal obligations are evaluated separately. That distinction becomes the foundation for everything that follows in the court's decision.
Caretaker, that you do all of those things. And I understand that. And from what I'm hearing, you are a good dad and you're doing those kinds of things. This is a monetary thing of cost to the state.
so a debtor's prison.
So what?
So a debtor's prison.
Probably what you're saying, it just is what it is. It's something that's owed to the state. It's like taxes. It's like the IRS. You still have to pay it back. And even this amount is a small amount. And I'm willing to work with you. I understand, but $50 a month doesn't sound like it is an immense amount to try and make monthly.
Okay, Judge, I also have, besides Rosaline, I have 5 other kids that
know.
live with me.
I know.
$50, especially with,
But you've created these kids and there's cost to the state and that has to be paid back. So that's what it is and where we are. So Ms. Thomas Schmidt.
Your Honor, I suppose what I was going to say in response to Mr. Anderson's assertions through his attorney aren't specifically necessary. Certainly some of the facts would be disputed based on what was testified to and stated at the hearing with Judge Winton Rowe, which Mr. Anderson and myself are the only ones who was present for. But the fact remains, $5 distributed to this case in 18 months is not an effort This is a legal requirement. It's an order of the court. And the fact that this child has special needs, the fact that Mr. Anderson apparently provides for the primary amount of care for this child doesn't change the fact that he has other obligations, just like it didn't change the fact that he has legal obligations to the elder. So I believe staying 15 days for a period of 1 year is appropriate so that Mr. Anderson understands that he has to meet all of his obligations, make a substantial effort at making all of his obligations. And that just isn't happening.
All right, briefly.
I again have no objection to that.
All right, and so here's the thing, and I understand, and I'm gonna tell you, I think everybody knows here, I'm a money judge. I make sure that people, it's part of life, that's part of the world, whether it's a fine or fee, whether it's a sanction, whether it's, you know, a repayment of costs. I do understand your situation, Mr. Anderson, and I do understand that you have other children that you are paying child support for and or taking care of a lot. And when you have them, it costs a lot to have a kid, especially the older they grow. And I'm going to say generally, and I generally, I'm like, I do go, Miss Thomas Schmidt, this is a small amount, $50. But I am willing, because I want to see you do well. I want to see you succeed. But I need to have this money paid back. All right. It needs to be paid back. Because the state didn't create the kid. The state didn't, you know, engage in any of those things. You did. And that's why ROA is here. And the state had to pay those birthing costs. All right. And so that's reimbursement. And Ms. Thomas Schmidt, I get completely your argument. And I do understand that $50 a month is a small amount. I'm willing to reduce it to $25 a month. Because to me, that's fair. And you're going to pay it back. Because if you don't pay it back, you know me, Mr. Anderson, I will send you to jail. All right. I don't want that to happen. I want both you and ROA and your other kids to be healthy, happy, and fed and all of those things. But I do need to make sure that the state gets paid back. And there's no interest on birthing costs, correct? No.
Correct.
So as long as you're paying it back, and $25 a month to me sounds more reasonable right now, given your situation, right? And you're nodding your head.
Yes.
And so you can pay that $25 a month?
Can we start it in September?
Correct. That's what I was going to do.
Thank you.
Right? Because I know you're in custody. And to me, when in some cases we have far more than this, that people ask to have payment plans that it'll take a lifetime to pay back. $25 a month will take a while to pay back. But I know you, Mr. Anderson, and I know that if you have extra money, you get paid a job and you get whatever, you want this taken care of.
I got a divorce settlement that's going in for contempt that I should have some money coming from.
And I know, or I feel and understand you're going to pay this off, right?
I will, yeah.
And because you want to get the state off of your back and you want me off your back. So I do believe that if you get extra money, you're going to pay it towards this and get this paid down, right?
I'll probably do my main case to try to get that paid down, but I will put some toward this.
Right, both, but then we'll keep reducing it. And then you don't have to be here because $25 a month, starting in September, all right?
What makes this ruling notable isn't simply the reduced monthly payment. The court pairs flexibility with a stronger consequence, sending a clear message that willingness to cooperate doesn't eliminate accountability. The outcome reflects an attempt to balance compassion with enforcement of the court's order.
Because you're out August 2nd, it'll be a year to be able to do this. But I am going to tell you, I'm going to do 20 days of jail, not 15. So that gives you more incentive of, I just want to, I lowered the cost, but it will be a bigger sanction if you're not able to pay it. Okay? You understand that?
Yep.
Okay. And so that's what we're going to do. And then we'll have another review hearing. All right.
Okay.
Just because I want to make sure everything's going correctly.
And
I want to make sure and hear how ROA is doing, how you're doing.
She'll be there.
I mean, she doesn't have to be
Oh,
here.
I'm bringing her next meeting.
And then, but does she comprehend and understand? I don't want her to know that her dad could be in trouble. So that's my thing.
She understands,
I don't want.
she could
her-
reprogram your computer, but she can't speak a normal sentence.
Yeah, I mean, I'd love to have her here, but would somebody be able to sit out on the bench with her? I don't want her to hear me say anything.
I almost
I
brought
have
her
to
with
say.
today. Just because I haven't seen her and it's my birthday.
Well, happy birthday.
Yeah, I remember this from Miss Schmidt. I'll remember this.
No, that is
No,
inappropriate.
I'm gonna make sure I'm
No.
not in here next year on my birthday.
Well, if that's what you mean in a positive way, but if you're saying it in a negative
I
way,
think of it in a positive way.
because if
I
it's in a
believe it.
negative way and you're making a threat towards
No,
Miss
I
Thomas
mean,
Schmidt,
Positive way. I will make sure I'm not in here.